We have some of the points related to valid offer. 2 or 3 points were remaining that we will be discussing today. So one thing which we had discussed was that offer may be express or implied, general or specific. It may be positive or negative. That I think we had completed till that particular point. So now we will be starting with the next. Offer is different from invitation to an offer. Yes, I hope that you have studied all these things and we can start with the discussion. Yes. So far, if you have any query related to anything, whatever we have completed till now in our 4-5 lectures, if you have any query, please go ahead. We will clear those doubts and then we will move forward. If you do not have any query, then immediately we can move forward. Yes. Any query? किसी को कोई भी डाउट रहेगा तो प्लीज पूछ लीजिए. Am I audible to all?
Yes.
Thank
Yes.
you. Thank you. Thank you. Yes. So we will start with, that means everyone has understood all the concepts that are being discussed so far. So you do not have any confusion, any doubt or any query. Offer is different from invitation to an offer. What does it mean? Who has read about it? ये हो गया था क्या उस दिन? लास्ट लेक्चर में हमने ये डिस्कस किया है क्या?
No, sir. नहीं हुआ है.
Okay, okay. Is my voice clear to all?
Yes, sir.
Yes, sir.
Because very few students are responding, so I need to check every time that whether I am audible or not. Okay, so nahi hua tha ye. Offer is different from invitation to an offer. Who is going to explain this? Fast, because first chapter is very lengthy. So offer is different from invitation to an offer. Now every one of you is aware of what it is. We have seen these particular invitation to offer. So everyone is aware of it. For example, when we go for shopping in a mall, there we see that various pamphlets, various posters related to invitation of an offer is displayed. That on this particular product, 10% is off, 20% is off, or the MRP is 50 rupees, but you can purchase this particular product for 40 rupees, 42 rupees, 43 rupees. Such type of offers are called as invitation to an offer. If we go to a grocery shop also, generally there is a practice that they display the list of items, and against that items the price list is also given. That sugar is so much rupees kg, then your rice, basmati rice is dash dash per kg. The items or main items which the grocery shop is having, they are, that chart is called offer. Now the price mentioned of a kg sugar on that particular price chart is called as invitation to an offer. It is not considered an offer in itself. Now, why it is not considered? Because you can negotiate on that particular price. You can negotiate with the shopkeeper that although it is written 45 rupees per kg, but I want to buy 5 kg sugar. How much you will be charging me for 5 kg sugar? Or how much concession you will be giving if I am purchasing instead of 1 kg, 5 kg or 10 kg of sugar? So you can do negotiation. So that is why it is called as invitation to an offer. Here, the shopkeeper cannot claim. How can you ask such questions when it is clearly mentioned on the price list that sugar is 45 rupees per kg? So that is the basic difference between offer and invitation to an offer. When we ask the shopkeeper that I want to purchase a particular product, and when he gives the rate of that particular product, then he is giving an offer to us. But if there is negotiation going on, then till the offer is finalized, it will remain as an invitation to an offer. Next one. Two identical cross offers do not constitute a contract. Identical cross offers. Two offers. Who will give me this example? Two identical cross offers. Okay, two identical cross offers, again very simple. Mr. A wants to sell his car for 50,000 rupees. When he gives the offer to Mr. B, who is ready to purchase or who has shown interest in purchasing car of Mr. A, when Mr. A gives this offer that I want to sell my Maruti 800 for rupees 50,000, instead of accepting that offer, Mr. A gives counter offer to Mr. B gives counter offer to Mr. A that I am ready to purchase your car, but not for 50,000. I want to purchase it for 40,000. So this is not called as offer and acceptance. When an offer is again, instead of being accepted, again the person gives in return another offer, then it is called as cross offers. And two identical cross offers cannot constitute a valid offer. So that is why that is the meaning of cross offers. Last one, an offer must be made subject to any terms and conditions. Now, why it is written so? It is written so because the person who is creating the terms and condition of the contract is not at binding that the term and condition should be fixed. Suppose Mr. A wants to sell his car and the car is 5 years old car. He has purchased the car 5 years back. There is no law which says that if you want to sell your Maruti company car or Hyundai company car, and if your car is 5 years old, then your particular model should be sold at 1 lakh rupees. Hyundai i10 should be sold at 1 lakh only. You cannot sell your car for more than 1 lakh rupees or less than 1 lakh rupees. So no such rules are there in law. So when a person wants to sell his house, a person wants to sell any product, or a person wants to sell his bike or his car or his property, the person who is selling it is having a right that he can create his own terms and conditions, how he wants the contract to be exercised. Mr. A who wants to sell his car, he may fix the price of the car for 50,000, for 60,000, for 70,000, for 1 lakh, for 2 lakh, whatever he feels. He is having the right. Why? Because he owns the car. So he is only the person who can decide or create the terms and conditions for selling the car. It is not the other person who can decide. Then how he wants the other conditions in the contract, whether he wants that money to be paid in cash or online transaction or in the form of DD or in the form of check, it is to be again decided by Mr. A, because he is creating that contract. Next, again, he is having a right that he can give 10 days time to Mr. B, that after 10 days you can pay me 50,000 rupees. On that day itself, there can be a rule that on that day itself you have to pay the money, or he can frame a rule that before the delivery of the car and papers to Mr. B, Mr. B should pay the entire 50,000 rupees to Mr. A. So terms and condition can be at the creator's choice. जो create कर रहा है contract, उसकी मर्जी से terms and condition वो रख सकता है. Only condition is all the terms and condition should be lawful. It should not be against any of the provision of law. So that was related to essentials of a valid offer. I hope that I'm clear to all.
Yes, sir.
Thank you. Please at least say yes. So I come to know that yes, everything is proper and you are able to listen at least. So we will drop this essentials of valid acceptance because it is exactly the opposite of offer. So very simple. Now we will move on to void agreements. So I'll just read out what is written on the slide and then we will discuss one by one all the void agreements. The agreements which are not enforceable by law are said to be void. All the agreements which are opposed to public policy are called as void. So very simple, any agreement which is against the provisions of law and which cannot be exercised in court of law is called as void agreement. Void, against law. First one, agreements by incompetent parties. Yes, now everyone is aware of what is incompetent parties. Under capacity of parties, at length we had discussed about this point. 5 different categories we had discussed under capacity of party. The same is to be applied here also. Who is going to explain me this? Agreements by incompetent parties are called as void agreements. Who is going to explain? Yes. Boys. कौन बताएगा? कैपेसिटी ऑफ पार्टीज हो गया है क्या हमारा? Have we discussed the term capacity of parties or not? Yes or no? At least say yes or no.
No, sir. Capacity of party नहीं हुआ है.
What's your name? Hello, what's your name? Swarna.
Yes, sir.
Okay. So we have not discussed the term capacity of parties, right?
Yes, sir.
Okay. I hope that you were present in all the lectures?
Yes, sir, I was present.
You are present because we have checked your attendance also. It is 100%, Suvarna. Right.
Yes, sir.
So I think that in the second session itself, we have discussed this when we were discussing essential elements of a valid contract. And at that lecture, in that lecture, we had discussed this term capacity of party. We had also discussed that if the capacity of party is missing, then the contract cannot be called as a valid contract. Anyone who was present during that session?
Yes, sir.
Or anyone else who feels that we have not discussed this?
Hello.
Yes.
Yes, sir. Anurag here.
Yes, Anurag.
Yeah, I think there are three terms. I just remember it. One was one who has completed 18 years of his age.
Very good.
Second is he must be a citizen of India. That
Very
means a
good.
residential of India. And third is he must be not lunatic.
Okay, very good. Very good.
Yes, sir.
So that, okay, very good. So that we have discussed. Suvarna, just try to recall. We have discussed better, and we will just have a quick discussion on what the incompetent parties are. Incompetent parties are what included under capacity of party. The party which are incompetent to enter into any agreement. And when we can say the parties are incompetent to enter into a contract, very simple. When one of the party to the contract or both the parties to the contract have not attained the age of majority. At that moment, we can say that both the parties cannot enter into a contract. So that we had discussed under capacity of party, and that was incompetency, or that will be called as incompetent parties. अगर कानून में ऐसी व्यवस्था है कि अगर आपको किसी कंपनी के साथ किसी और व्यक्ति के साथ कॉन्ट्रैक्ट साइन करना है तो आपकी एज 18 साल होनी चाहिए या 20 साल होनी चाहिए या 25 साल होनी चाहिए। तो जब तक आपकी वो एज नहीं हो जाती तब तक अगर आप किसी के साथ भी कोई कॉन्ट्रैक्ट साइन करते हैं तो वो कॉन्ट्रैक्ट क्या कहलाएगा? वॉइड एग्रीमेंट, बिकॉज at the time of signing contract you were incompetent to sign the contract. So that is first. Second one, what Anurag said, is lunatic, or a person who is of not sound mind. That also we had discussed, that both the parties to the contract or one party to the contract should be of sound mind. If one party is of unsound mind, then it is इनकम्पिटेंसी ऑफ पार्टी, इनकम्पिटेंट पार्टी। अगर मैं पूरे होशो हवास में किसी पागल व्यक्ति के साथ कोई कॉन्ट्रैक्ट करता हूं तो मेरा कॉन्ट्रैक्ट क्या कहलाएगा? वॉइड कॉन्ट्रैक्ट। उस कॉन्ट्रैक्ट में अगर मुझे कुछ लॉस हो जाता है, एक पागल व्यक्ति मुझे आके कहता है आप मुझे अभी 1000 रुपए दो, मैं 2 दिन के बाद आपको इसके 10,000 रुपए रिटर्न दूंगा या 1 लाख रुपए रिटर्न दूंगा। ऑफर बहुत अच्छा था, मैं उसे 1000 रुपए निकाल के दे देता। 2 दिन के बाद वो नहीं आता है, तीसरे दिन वो बोलता है कौन से पैसे, कैसे पैसे, मुझे नहीं पता। मैं उस व्यक्ति को उसके ऊपर अगर केस करता हूं तो क्या कोर्ट मेरा जो एप्लीकेशन है केस का वो वैलिड ठहराएगा?
No.
नहीं, because the court says, the rule says, the law says that it will be considered as incompetency of party. One of the party to the agreement was incompetent to perform the contract. Next thing is, both the parties or either party should not be under the influence of alcohol or other drugs. अगर किसी ने नशे में कोई कॉन्ट्रैक्ट साइन किया है तो वो अगर बाद में उसको ब्रीच करता है, उस कॉन्ट्रैक्ट को ब्रेक करता है और कोर्ट में अगर ऐसा प्रूव हो जाता है कि एक पार्टी ने नशे के अंदर दूसरी पार्टी से साइन लिए हैं, तो ये कॉन्ट्रैक्ट क्या कहलाएगा? इनकम्पिटेंट पार्टीज. So capacity of party means both the person should be major, they should be of sound mind, both the person should not be under the influence of drugs or this alcohol. The next one is that a diplomat or a person who is working in different, representing own country in other country without the prior sanction of his parent country cannot enter into a contract with a national of another country. So that is again considered as a void agreement. A person who has become bankrupt and it is declared by the court that this person has gone bankrupt, or now he will be considered as an insolvent person. Now that particular person is again do not have the capacity to enter into a contract with another person or another company or another party. So 5 points we have to remember: that both the parties or either party should be major, both the parties or either party should not be under the influence of drink or drugs, both the parties or either party should be mentally sound, both the parties or either party should not be in the services of the foreign service who are representing their foreign country, and without permission they are not entering into a contract. And the last one is that both the parties or either party should not be declared by the court as bankrupt or gone insolvent. So that is incompetency of parties. Agreements made under mutual mistake of facts. That also we had discussed when we were discussing the another important essential element of a valid contract, and that is what? When we discussed about free consent. At that time we had discussed this: agreements made under mutual mistake of facts. Mutual mistake means when mistake has been committed by both the parties to the contract, then it is called as mutual mistake. एक ही पार्टी से गलती नहीं हुई है, गलती दोनों पार्टियों से हुई है। ऐसी सिचुएशन में क्या होगा? वो एग्रीमेंट वॉइड एग्रीमेंट कहलाएगा, वो इंप्लीमेंट नहीं हो सकता। Yes. Next one, agreement, the consideration or object of which is unlawful. And next one is agreement, the consideration or object of which is partly unlawful. तो अगर पूरा ऑब्जेक्ट अनलॉफुल रहेगा तो भी वॉइड है, आधा लॉफुल है आधा अनलॉफुल है तो भी वॉइड। अब सपोज फॉर एग्जांपल, if somebody is entering into a business of betting, and for that if he is entering into a contract with another person, then that particular contract will be called as void contract, because betting is considered as against law. It is prohibited in our country, so it is against law. When we talk about partly lawful and partly unlawful, is that suppose I have a house and I want to give my house on rent to a particular person. So giving house on rent is lawful, but if that other person uses that particular house for running the business of betting, then it is unlawful. So partly lawful, I have rented my house to Mr. B, that is lawful. But when I know that this rented property will be used by Mr. B for some unlawful purpose, So half part is lawful, half part is unlawful. It will be called as void agreement, which cannot be entertained in the court of law. Next one, agreements entered into without any consideration. Consideration, we have discussed the meaning of consideration also, and it is very simple, getting something in return. Both the parties in the contract should get something in return, and that something in return should be lawful. If it is not lawful, then it is not accepted. If it is lawful, then it is accepted. Agreement made in restraint of marriages. Now, this is a right which is given to all the citizens of India. On attaining the age of 18 years, a girl gets the right to marry and marry a person of her choice. Similarly, a boy attaining the age of 21 years gets the right to marry, and he is having a right to marry a girl of his choice. So that is called as their right of a boy or right of a girl. So agreement that are made in restraint of marriages are considered as a void agreement. The example is very simple. Now, Mr. A, if offers Mr. B that I'm ready to pay you 50,000 rupees for a condition that you will not marry girl called Miss C. And if Mr. A takes that money and still marries Miss C, Mr. B cannot take Mr. A to the court of law to recover that particular money. Why? Because that agreement will be called as void agreement. In some other clause, he can recover the amount, but in this, in contract act, that his claim, his suit will not be admissible in the court of law, because he had signed that agreement, even if it is in written form, even it is on 100 rupees stamp paper, even if it is stamped by and signed by all the witnesses present, still this will not be considered as a valid document. Why? Because this agreement breaches the right of marriage, which is being given by law to a boy and a girl. So that is called as agreements made in restraint of marriages. And a proper term is used in law for such type of contracts, and that the term is called as contract out. अगर हम किसी के साथ भी कोई भी एग्रीमेंट करते हैं, सपोज मुझे नौकरी की बहुत जरूरत है, मैं इंटरव्यू के लिए जाता हूं और there is a law about minimum wages to be paid to the employees. You might be aware of that. That was passed in the year 1948, way back. So every organization is bound to follow that rule. ठीक है, ये सबको फॉलो करना ही पड़ता है. एक मिनिमम वेज रहता है, 10,000, 5,000, 6,000, 15,000, 20,000, जो भी लॉ में लिखा हुआ है, उससे कम अगर आप ऑर्गेनाइजेशन में मैनेजर हैं या मालिक हैं ऑर्गेनाइजेशन के, आप उससे कम अपने एम्प्लॉइज को नहीं दे सकते. तो सपोज एक एम्प्लॉई जिसको बहुत जरूरत है जॉब की, क्योंकि उसे अपनी पूरी फैमिली संभालनी, वहां पर मिनिमम वेज का स्लैब है 10,000 रुपए, पर बहुत सारे लोग अप्लाई कर रहे हैं उस जॉब के लिए. इंटरव्यू के दौरान मैनेजर उससे क्वेश्चन पूछता है, क्योंकि बहुत सारे लोग हैं, मैनेजर के पास एक ऑप्शन है अच्छा कि जो कम कोट करेगा उसको हम लोग ले लेंगे। मैनेजर उसे बोलता है कि कितना सैलरी आप लेंगे। व्यक्ति बोलता है कि जो आप देंगे वो मुझे चलेगा। 10,000 का स्लैब लॉ में फिक्स किया गया है, उससे कम कंपनी नहीं दे सकती। मैनेजर सिचुएशन का फायदा उठाता है और मैनेजर उसे कहता है कि ठीक, अगर आप 7,000 रुपए में तैयार हैं तो हम लोग आपको जॉब दे सकते हैं। पर मैनेजर उसे कहता है कि आपको बॉन्ड साइन करके देना पड़ेगा कि यू आर रेडी एंड यू आर willing to work on a salary of 7,000 rupees and you have to sign the document. Plus, it is to be counter-signed by the HR manager and the witnesses of both the parties, ताकि ये डॉक्यूमेंट लीगल डॉक्यूमेंट हो जाए। हम लोग जानते हैं, पहले से हमें पता है कि अगर एफिडेविट बॉन्ड पेपर पे रहता है तो इट इज एडमिसिबल इन द कोर्ट। तो वो सब प्रोसेस किया जाता है। अब ये प्रोसेस सब चीजें करेक्ट हैं, पर अगर एक भी चीज इसमें से इनकरेक्ट है। क्या इनकरेक्ट है? कि यू आर गोइंग अगेंस्ट द लॉ। यू आर, इवन इफ द पर्सन इज राइटिंग, वो लिख के दे रहा है कि मुझे पूरे होशो हवास में मैं लिख के देता हूं कि मुझे 7,000 रुपए सैलरी मान्य है, मुझे 10,000 रुपए सैलरी नहीं चाहिए, ऐसा अगर वो लिख के देता है, साइन करके देता है, तो भी ये इनकम्पिटेंट कॉन्ट्रैक्ट कहलाया जाएगा, वॉइड कॉन्ट्रैक्ट होगा। और टर्म एक यूज की जाती है लॉ में, एंड दैट इज कॉल्ड एज contract out. So all the contracts, even if they are made in written form and everything is present in those contracts, but if those contracts are against the provision of any law in force, then those contracts are called as contract out. तो वो कॉन्ट्रैक्ट आउट है, इसीलिए उसको टर्म ही यूज किया गया, कॉन्ट्रैक्ट आउट। सो दोस कॉन्ट्रैक्ट्स आर रिजेक्टेड बिकॉज ऑफ
डेरी डिप्लोमा
मोहित सर। हेलो मोहित सर। हेलो। Okay, thank you. Am I audible? Am I audible?
Yes, sir. Yes, sir. Yes, sir.
Okay,
Yes, sir.
and you can see my screen also.
Yes, sir.
Yeah, and there is a one more thing, sir. The
Huh.
lecture was organizational behavior, and you are conducting the legal aspect of business.
Because what has happened, I am still in the college
Yeah.
itself, and I have forgotten my pen
Okay,
drive
okay,
at my
no
place
issue, no
only.
issue. Yeah, yeah,
That
no
was the
issue.
reason why I was having in my mobile the presentation of legal aspects of business. So
Yes,
that
yes,
is
yes,
why I
sure.
decided to continue. Okay.
Yeah, yeah, okay. Yep.
Okay. 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 What's the time now?
6:35, sir. 6:35.
Please stop me at 7. Please stop me at
Yes,
7.
yes, yes, sure. Yeah, sure, sir.
Okay. Thank you. Yes. So that is called as agreement made. We had discussed the examples related to agreements made in restraint of marriages. So anything, any agreement, even if all the things are present, even everything is in written form, still that agreement will be rejected by the court if it is conducted, if it is signed against some or the other provision of law. Now, the next type of void agreement is called as agreements made in restraint of trade, business, or occupation. Again, as a citizen of India, every Indian citizen is having a right that we can start our own business. We can choose the occupation where we want to do career. and we can have a choice of trade to start. No one can force us that no, instead of this, you have to start this business, because we are citizens of free India, and the Constitution has given this right to all the citizens of India, that they are free to start the business of their choice. They are free to be in a particular occupation. Only thing required is that it should be lawful. It should not be unlawful. तो मैं जो बिजनेस चालू करना चाहता हूं, मैं जो प्रोफेशन चूज करना चाहता हूं, मैं वो कर सकता हूं. Only condition required is that it should be legal, it should be lawful. Now, any agreement which stops or which prohibits another person from starting a particular business or entering into a particular occupation or trade is considered as a void agreement. If somebody offers, suppose Mr. A is having an electronic showroom at a particular location or locality. Now, in the same locality, Mr. B is also planning to start his electronic showroom. As Mr. A gets the news that Mr. B will be opening his new showroom related to electronic items after 10 days, he approaches Mr. A and he offers Mr. A that I am ready to pay you 1 lakh rupees if you confirm that you are not going to start your electronic business in this same locality. So this particular condition, even if Mr. B accepts and later on he breaks that condition, breaks that promise, still Mr. A cannot try Mr. B in the court of law, or he cannot file a suit against Mr. B for non-performance of contract. Why? The reason is very simple, because he has entered into the contract which is against the provision of law. Law has given these rights, and if you are entering into anything which is against your fundamental rights, then it is against law. So that is called as agreement made in restraint of trade, business, or occupation. Now, agreements made in restraint of legal proceedings. Again, it is very much similar to the above 2 points. Who is going to explain me this? Agreements in restraint of legal proceedings. Now, everyone is aware of what legal proceeding is. Restraint means stopping or prohibiting. Yes, who is going to explain me this? कौन explain करेगा? बहुत simple है. Very much similar to the other 2 points. Yes. Who is going to explain me this? Girls, boys, it is very simple. Try to be part of discussion. And in our next lecture of organizational behavior, we will be discussing about Johari windows, and we will be discussing about transactional analysis. Now, these 2 are very interesting if you participate in the discussion, and you will be able to participate in the discussion if you are reading about these things. If you come prepared in the class, then it is very interesting. Otherwise, it will not be so interesting. So that is when we will be having our next OB lecture. maybe tomorrow or day after tomorrow. Tomorrow, I don't think we are having a lecture on OB, but day after tomorrow, when we will be having a lecture on OB, then we will be discussing those two concepts, which is called as TA or transactional analysis and Johari window. So come prepared for that. Who is going to explain me this void agreement? Very simple. लीगल प्रोसीडिंग क्या रहता है सबको पता है. रेस्ट्रेंट का मतलब स्टॉप करना किसी को, या प्रोहिबिट करना, या मना करना. बोलिए जल्दी से, फास्ट. यस सुवर्णा. अनुराग.
Hello, sir.
दीपिका.
Hello, sir.
Yes, please go ahead.
Sir, in my view, agreement in restraint of legal proceeding is like, sir, if any person is restricting other person from enforcing his contractual rights, like if anyone is going to court for any proceeding, if other person stops him from doing so, so it is the agreement of legal proceeding.
Can you come again? Your voice was not clear. Can you come again?
So like I am explaining it with example.
Very good.
Sir, if any person is going to court for any legal proceedings,
Yes.
if person A stops him from doing so, so it may be called as agreement in restraint of legal proceedings.
What's your name?
Abhishek Pund.
Abhishek, very good. It is absolutely correct. So as the name itself says, agreement in restraint of legal proceedings. When Mr. A and Mr. B are entering into a contract, Mr. A, who has created the terms and conditions of the contract, he also creates a condition that in case of breach of contract in part of Mr. A or by Mr. A, Mr. B will not take Mr. A to the court of law, or Mr. B will not file a suit against Mr. B for non-performance of contract or for breach of contract or for violating any terms and conditions of the contract, and he will not take Mr. A to the court of law. अगर ऐसा लिख के भी दिया जाता है तो भी कोर्ट में वो मान्य नहीं होता, and it is categorized as agreements in restraint of legal proceedings. Because again, as a citizen of India, each and every citizen is having a right that if any injustice has been occurred to you, if because of any person, if you have suffered losses, you have every right to proceed to the court to claim compensation from that particular person who has made you face losses. So that is the meaning of agreement in restraint of legal proceedings. Now the next one is all agreements, the meaning of which is not certain. Again, that we had discussed in the point when we were discussing essential elements of contract. So it is very simple. All agreements, the meaning of which is not certain. The object should be certain, all the terms and conditions should be certain, then only it can be converted or it can be called as a valid contract. If any terms are not certain, the object is not certain, then again, that is not a valid contract. Wholesaler is ready to sell oil to the retailer. Which type of oil? If it is not mentioned, that means it is not certain. It cannot be enforced by the law. If price is not mentioned, okay, wholesaler is ready to sell edible oil. Which type of oil? To sunflower oil. 10 tins of sunflower oil, each tin containing 15 kg of oil or 15 liters of oil. For how many rupees? If price is not mentioned, again, certainty is missing. So all agreement, the meaning of which is not certain, the terms and conditions are not certain, they are categorized as a void agreement. Next one, wagering agreement. Wagering means betting. So any agreement which has been created by either party to the contract, if they are entering into a contract or an agreement related to betting or wagering, then it is not accepted in the court of law. Next one, agreements contingent on impossible event. Contingent means dependent. The agreements which are dependent on impossible events, they are again called as void agreement.
Void contract. Yeah.
Void agreement. Next one, agreement to do an act impossible in itself. Again, that we had discussed when we were discussing the essential elements of the contract. Now we will talk about, there is a concept called exceptions to no consideration, no contract. We have seen while discussing the essential elements of a valid contract that if consideration is missing, there cannot be a contract. If consideration is unlawful, there is no contract. But there are certain exceptions to the rule of no consideration, no contract. Normally, it is said that if consideration is missing, that agreement cannot be converted into a valid contract. But here, 4 or 5 exceptional rules are there, which says that even if one party is getting something in return, the other party is not getting that something in return, still in some cases, if such situation is prevailing in a particular contract, then that contract can also, then agreement can also be converted into a valid contract. And these exceptional rules are, or these exceptions are, promise made on account of love and affection. Promise made on account of love and affection. When one party is promising to do something to another party, why the first party is promising? The promise is out of love and affection towards the other party. And still here, only one party is doing something or getting something, the other party is not getting something in return. Still, the contract is valid in the eyes of law, and this contract can be enforceable by law also. Now, for example, very simple example, everyone is aware of, and the example is creation of will. WILL, will. will का क्या मतलब है यहां पर? will means which a person creates in favor of his family members, that in case of some eventuality, in case of my death, my property, my bank balance should be given to my wife, my other relatives, or my son, my daughter, or whatever the names he mentioned in that particular document, and that document is called as will. So here, If father is entering that will and he is entering that with his family member, maybe wife, maybe children, maybe other relative, here father is giving his property, but he is not expecting returns in terms from the other family members. Normal case, what happens is that Mr. A is selling something or giving something, and Mr. A is also getting something in return for that particular thing. It can be an electronic item, it can be any other item. But here in this case, one person is giving his property, or he is mentioning in the document that after my death, my property should be given to the following members. Or after 1 year, even if I am alive, or from 15 days onwards, even if I am alive, I want to distribute my property to this member of the family. So he is not getting something in return, but he is giving his property to his family members. So why he is giving? Because of love and affection towards the family. Will is always enforced by law. If it is in written form, if proper rules and regulation for creation of will is being followed. रिटन फॉर्म में विल होनी चाहिए, तभी वो एक्सेप्टेबल है. बहुत सारे रूल्स एंड रेगुलेशन है विल क्रिएट करने के, विल बनाने के. अगर वो सब फॉलो किए जाते हैं तो कोर्ट में वो एडमिसिबल होती है. वहां पर दूसरी पार्टी को कंसिडरेशन के तौर पर कुछ नहीं मिला, फिर भी वो एडमिसिबल होती है. सो दैट इज व्हाई इट इज कॉल्ड एज विदाउट कंसिडरेशन, but still it is acceptable. Next one, promise for compensation of voluntarily act. If someone promises the other party that voluntarily, without any offer, if someone is doing something for the other person and the other person, he says that okay, for your this voluntary act, I will give you 1,000 rupees, 2,000 rupees, or 5,000 rupees, or I'll give you my bike or car, or I'll give you my flat. Here, one person is giving something in return, the other person is not, then still this will be called as a valid contract. Voluntary services. Normally in contract, what happens? One is giving the offer, the other person is accepting the offer. Here, no offer is given. One person is doing some voluntary act for the other person, and other person, because of that voluntary act, if promises that he or she will be giving something in return for that voluntary act, then it is called as a valid contract, because of and it is included under the exception, no consideration, no contract. Next one, promise to pay any time barred debt. A debt means what is debt? सबको पता है debt मतलब क्या रहता है. DEBT. The pronunciation is not debt, it is debt. B is silent. Yes, what is?
So the amount of money we have to pay to someone.
Debt. Very good. It is absolutely correct. जिसको हम लोग अगर हिंदी में बोलेंगे तो क्या बोलेंगे उसे?
उधारी.
उधारी, कर्जा, बकाया. Very good. Very good. So promise to pay any time barred debt. Debt. Time barred, which is limited by time. Time barred means limited by time. एक महीने के अंदर A is promising Mr. B that if you give me a loan of 1000 rupees, I will repay the loan within a period of 1 month and with an interest of 10%. एक महीने की मुदत थी, एक महीने के बाद अगर वो नहीं दे पाता है तो वो क्या हो गया, टाइम बार्ड डेट, उसका टाइम निकल गया है, पर इसका ये मतलब नहीं है कि उसका पैसा डूब गया। अगर वो एक महीने के बाद मिस्टर बी को देता है तो दैट विल अगेन, मिस्टर बी को कुछ भी देने की जरूरत नहीं है बिकॉज ही हैज ऑलरेडी गिवन द मनी। सो टाइम बार्ड डेट, again one person is giving something in return, other person not, it is considered as a valid contract under no consideration, no contract. Next one, contract of agency. Contract of agency, a complete chapter we will be discussing once we complete this contract act. It is covered under a different contract which is called as contract of agency. Under contract of agency we will be discussing that three parties are involved. Which these three parties are, that we will be discussing at the time of contract of agency. So we will not discuss now, we will talk about this at the time of contract of agency. So contract in brief, just we will have a look what is contract of agency. Contract of agency is a type of contract which is entered into three parties. One party is called as the principal, one party is called as principal, the second party is called as agent, and the third party is called as the company. So company, principal and agent. So that we will be discussing in our third, once we complete this particular chapter. And last one we will be discussing now is completed gifts. Gift everyone is aware of. So when we are giving gift to someone, we are not expecting anything in return. Gift includes donations also. मेरा प्रमोशन होना चाहिए, अगर इसके लिए मैं साईं बाबा के मंदिर में जाके 100 रुपए, 200 रुपए या 500 रुपए दान करता हूं, और अगर प्रमोशन नहीं होता है तो आई कैन नॉट एक्सपेक्ट दैट देयर वाज इन रिटर्न मिसिंग, कंसिडरेशन इज मिसिंग, दैट I have given 500 rupees, but in return, I have not received the promotion. So completed gift, it is categorized as completed gift. You have, donation means you have given a gift to a particular temple, to a particular god. So if you have given that donation, that will be considered as a valid contract. And in return, if you are not getting anything, you cannot file a case in the court of law that there was missing of consideration, so I want my money back. So that was the exceptions to no consideration, no contract. What's the time now?
Yes, sir. Time is up now.
Okay.
7 p.m.
So
Yeah.
Okay, thank you. So quickly we will just discuss in 2 minutes what is performance of contract, and then a homework to you will be that please just take a screenshot of this slide, types of performance. Take a screenshot of this slide. There are two types of performance. One is called as actual performance, the other one is called as attempted performance. Okay, take a slide, screenshot of this slide, and then take this screenshot also. Essentials of a valid tender. Okay, take a screenshot of this slide also. Who must perform? So we will try to complete these 3 slides in our next lecture on legal aspects of business. Now, performance of contract. Before we wind up the session, I'll just give you the meaning of this, and remaining 3 slides you come prepared for the lecture and we will discuss. Performance of contract. The term performance means that the party to the contract have fulfilled or carried out their respective obligation arising out of the contract. So performance of contract, it is very simple. Whatever has been written in the contract, if it is performed by both the parties to the contract, it is called as contract has been performed. It is called as performance of contract. A wanted to sell his car, B wanted to purchase that car. A has sold the car, B has paid the price, and it will be called as performance of contract. तो जिस चीज के लिए, जिस कंडीशन के लिए, जिस ऑब्जेक्ट के लिए कॉन्ट्रैक्ट क्रिएट किया गया, जब दोनों भी पार्टीज प्रॉमिस कंप्लीट कर देती है तो कहा जाता है कि कॉन्ट्रैक्ट हैज बीन परफॉर्म्ड. इट इज कॉल्ड एज परफॉर्मेंस ऑफ कॉन्ट्रैक्ट. So we will now stop, and remaining 3 slides come prepared in the class. We will discuss. And next thing, as we have already discussed, that you will be coming prepared for transactional analysis and Johari window for OB session also. So please take a note of it. So thank you everyone for being present in today's session. We will stop here. Thank you.
Hello.
Yes, Anurag.
Hello. Sir, can you give me that previous slides so that I can take the screenshots?
Which slide?
That void agreements.
Which? Come again, Anurag.
The void agreements, like हम कब मानेंगे agreement void हो गया?
This slide you are talking about?
हाँ, this slides, the first one.
Okay. After the complete unit, I'll be sharing this PPT, I'll be sharing notes, I'll be sharing other learning material on legal aspects of business. But why you should take screenshot? Because it will be easier for you to prepare for the next class. Right? Yes. Thank you everyone for being present in today's session. Thank you.
Thank you, sir.
Thank you, sir.
Thank you. Thank you.